Right. Good morning, everyone. Welcome to the 200th District Court. This is Judge Jessica Mangrum. We're here for an emergency hearing in the interest of MW. And we're here. I've read the application. Let's see. Miss Lovelace, do you want to weigh in?
Yes. Hi, I'm the appointed guardian ad litem. I was appointed on April 15th. This is a case where Judge Martinez Jones retained it and wanted an opinion on conservatorship. And so Malik is currently placed with his fictive kin mother, Miss Harris, and Miss Barker lives in Alabama. This case is somewhat contentious due to what each of them perceive as the history and how Malik came into Miss Harris's care. And so Malik has summer school in June, and Ms. Barker is requesting 3 weeks with Malik. It's been unsure as to whether or not she is in agreement for him to go to summer school. I've had a conversation with her in text message about the need for his education to come first. I am concerned if she does have possession of Malik for 3 weeks in Alabama, that it's going to be somewhat stressful for him because he has only seen his mother once for 2 hours in a supervised visit.
Your Honor, I'm sorry to cut Ms. Stephanie off, but I have begged and pleaded since April the 15th to have weekend visitations with him via Zoom, via Teams, via whatever app is easily accessible to them. I don't hear anything back, Your Honor. I have begged and pleaded to see him for his birthday. I was court appointed to be able to see him on Mother's Day. I did not see him until after Mother's Day. Your Honor,
Okay.
all I'm trying to do is be able to gain a bond with Malik, and I feel like I'm being met with brick wall after brick wall when I try to gain this bond with Malik and get to know him and allow him to get to know me as a person.
Okay. The court has asked to hear from the guardian ad litem on this case, and this is an emergency hearing. It's not on your application, so you don't have anything in front of the court today, Ms. Barker. Ms. Lovelace, you may continue.
Yes, I'm concerned about Malik going for 3 weeks in Alabama. I think Ms. Barker struggles to understand the complexity of her relationship with her son. I'm also concerned that Malik will be told negative information about Ms. Harris. I'm certainly concerned that Malik has only had one in-person visit with her, and it was supervised for 2 hours. I feel like there is a need for family therapy for Malik and his mother to develop a bond. I've requested that Malik participate in individual therapy with Rhonda Cappy. I would like Ms. Barker to come to Austin in order to have supervised visits with Malik so that he feels more comfortable in his environment. And I would like Ms. Barker to engage in family therapy, individual therapy, because she has a lot of anger and resentment towards Ms. Harris.
Ma'am, I don't have any anger or resentment towards Ms. Harris.
Ms. Barker, you are not allowed to interrupt. This is a courtroom, okay? We do not speak at the same time as someone else is speaking. Go ahead, Ms. Lovelace.
I'm concerned because he just found out that Ms. Barker was his bio mom. Throughout his life, he was under the impression that Ms. Harris was his biological mother. He found out the circumstances during the CPS case, as well as he does have a mother, and it is Ms. Barker. And so that is very confusing for him. And although he was supposed to have individual therapy while the department was involved, I don't believe that was set up. So he is worried about going for 3 weeks. He is unsure if he will be returned, and he is going with someone he doesn't even know. And I have great concerns about his mental health and his emotional well-being. And he is also concerned that he may not be returned. So I'm asking that Ms. Barker come to Austin and have supervised visits with Malik in order to allow him to feel safe and to get to know his mother.
Okay. And Ms. Lovelace, if you would I haven't had time to go through everything in this file, but how did the child find out about Ms. Barker? How did that come about?
About finding out that she's his biological mother.
Yes.
Okay, so CPS got involved and removed Malik and his sister when Miss Harris was pulled over for a warrant. During that time, the DPS officer asked Miss Harris about her children. And when Malik's information was run, there was a missing persons report out of Alabama. It was reported in 2019. And so Malik was removed. He was placed in the care of Miss Lomax, which is Miss Harris's mother. And there was a short case with CPS. It was a temporary managing conservatorship case. And so during that time, he was told by the department that Miss Barker was his bio mom. So,
Okay.
she did not know
So the
that.
missing person report was filed when the child was 5 years old?
Yes, Judge. It was filed in 2019 by Miss Barker.
Okay. All right. Okay. Thank you, Ms. Lovelace. Let me go ahead and hear from the applicant, Ms. Harris. Is there anything else? I have read the application, Ms. Harris. I don't know if you have anything else to add.
No, ma'am. That was all. The biggest thing for me was Miss Barker has a way of emailing me. I've made sure that she had my email. I do not have her phone number. I have no way of reaching out and picking up the phone to call her. If it was not for Miss Lovelace, I wouldn't even know that she's attempting to come and pick him up on the 27th, being that me and her had a whole conversation that was recorded by Miss Lovelace of me informing her that he does have summer school this year. And also, I turned in paperwork from his school to Miss Lovelace, and Miss Lovelace emailed it to Miss Barker, confirming the dates that he has summer school. Once Miss Lovelace filed her recommendations, I never heard anything. Malik has had one video visit supervised by Miss Lovelace. After that, there was no more reaching out by Miss Barker to ask for another visit or anything else like that. She has my email. I have not heard anything at all. Not one time has she emailed me.
Okay.
The last time she emailed me, it was she wanted to set up a meeting about his summer school. Then the paperwork for his summer school was emailed to her by Miss Lovelace. After that, I have not heard anything else. Since the last meeting since the last visit she had with him, I haven't heard anything from her, not one time.
Okay. Thank you. All right, Ms. Barker, now is your opportunity to tell the court your side of the story. And just
But
know that
the
this
first
is the court
time-
hearing.
Yes, I understand that. I'm fully aware. I would like to start off by saying, when I have Malik in my care, the only thing on my mind is building a bond with Malik. Nothing else needs to be talked about outside of a therapeutic environment. And I have been advocating for that from the beginning. Also, I have begged and pleaded to see Malik. I have begged and pleaded on the Family Wizard app. I was told via the courts that all of this would be handled via the Family Wizard app because the courts did not want us exchanging our information. Ms. Lovelace wants us to exchange our information. I don't want that because I want everything to be recorded via the courts. So this does not happen, Your Honor. I cannot afford to keep coming to Texas every weekend. I have a 3-bedroom house. I have 2 dogs. I have a cat. I have 2 other children in my care that I have to take care of. I don't have the money to continually up and go to Texas. Also, I would like to add that Miss Harris has multiple felony warrants open on her in the state of Alabama, which is why she does not want to come to Alabama, because she is afraid of what might happen to her within the courts and jail here. Because yes, she does have open felonies here in Alabama. Also, I am concerned with my child living in a house with 2 felons. I'm concerned for his safety because even in the courts, it says that he's been witness to domestic violence between Miss Harris and whoever the man is. I've never had any charges on me at all, Your Honor, and I'm being made to feel like I'm a martyr. I did everything I was supposed to. I have begged and pleaded to see my child through the Family Wizard app. Miss Harris cannot tell me that she did not see those because she responded twice to those in the Family Wizard app. I have begged Miss Lovelace to be able to see my child. I have begged Miss Lovelace to be able to set up a continuous schedule on the weekends where I can at least have 20, 30, 40 minutes on the phone to gain this relationship with him. I have waited and waited and waited. I have never received anything. I never hear anything. It's always Miss Lovelace said, Miss Harris said this, and Miss Lovelace doesn't ever want to hear what I have to say, Your Honor. And I feel like that is a misrepresentation on Malik because he is being hindered from knowing his family. I have begged, I have pleaded, I have tried for the past 10 years to see my child. And I feel like I still can't see my child. It is important. His education, I have told from the beginning, his education is very important. I'm fine with him going to summer school. That's completely fine. His education is very important and key to me. I would love for him to grow up and be a smart individual, graduate high school, go to college, and be the greatest human being he can be, Your Honor. I would love for that. But at the same time, I feel like my other two children, as well as myself, deserve to know Malik as a human being. And we are being robbed of that. I don't know how much more I can beg and plead and talk to a brick wall to ask about my child and never hear anything back, Your Honor. I can email, I can text, I can call Miss Lovelace, I can get on the Family Wizard app. Why is nothing ever being answered until Miss Harris has something to say about it? That's not fair to me. And I feel like I'm being represented trying to even see my child. I don't have the money to continue going back and forth to Texas. That's 1,500 miles back and forth every weekend. That's $800 just to get there and back. Nobody in their right mind in this economy has that money to be able to do that and still be able to pay their bills and fend for their other children as well as Malik. I have 2 other children. I take care of these 2 other children.
Okay. All right. And Miss Lovelace, I believe you sent in a proposal as well as what the court had received from Miss Harris. Is that correct? As far as the actual order?
Your Honor, may I say something?
Yes, briefly, but I've got another hearing at 11, so make it quick.
Yes, ma'am. 2 seconds. As far as that family app wizard, I've even let the judge know that on my side, it does not work properly on my phone. I've even notified Miss Lovelace about that and Miss Barker. That is why Miss Lovelace had us emailing each other with her as the third party in the emails so that it is tracked. And it is not just an email between the 2 of us. It is with Miss Lovelace on there as well.
It was court ordered that we not have anybody's email address. It was court ordered that we not have each other's phone numbers. It was court ordered that all of that way it can be recorded. I don't feel comfortable giving her my phone number. She has my address. I don't even know where Malik stays at.
Okay. I am not going to tolerate any further interrupting, Ms. Barker. Okay, Ms. Harris, you've been ordered to use the Our Family Wizard app. If you are having problems with the app, you need to get them addressed. Period.
I have came to the court with the judge and I've brought it to the attention
of the judge
and Ms. Lovelace.
I'm sorry, you need to call Our Family Wizard and get technical support to get it working. Excuses are not helping, okay?
Understood. And I've been trying to get it fixed.
Do it. Okay, Ms. Lovelace, was there anything else to add after hearing from the other parties? Oh, you're on mute.
I apologize. I would like to clarify Ms. Barker's statements about her children. Her 14-year-old son lives in Michigan with that father. She does have 1 child in the house with her currently. He is 7 years old. Additionally, I had made a request that the parties switch to app close so that I could be added and I could see the communication. There seems to be some issue with Our Family Wizard. I would suggest that they use app close. It's a free app and I could be added and I could see all of the communication. I do request that phone numbers do be shared. I think this is what makes it difficult. And yes, there have been emails exchanged with me on there, but I do believe that app close may be a better choice for the parties.
Okay, and that's primarily due to the cost concerns.
There just seems to be some technical issues with the app, and I think using app close would just be easier for the parents.
Your Honor, can I say something?
And Ms. Lovelace, why do you want the parties to exchange numbers?
In case of an emergency, it isn't to communicate in text message, but it's certainly for an emergency. That's all that I'm requesting it for. The communication can be an app close.
Okay. Ms. Barker, was there something else?
Yes, my 14-year-old may live in Michigan with his father, but from the end of May to the end of August, he's with me. He'll be here this next weekend. He was supposed to be here this weekend coming up because we were all going to go to Texas with my dad to see Malik. Now that that's not happening, we went ahead with his dad's original schedule at the end of May on the 29th. He bring him down here. And he will be here until August 27th, 28th, because their school in Michigan does not start back until September.
Okay.
Also, Your Honor, I would like to add that I don't want Miss Harris having my phone number because of her record and the fraud and this and that on it. I feel like that's just not an ideal thing. I'm trying to protect myself as well as my household and my children. Her having my phone number, she already has my address, she has my email address, she has my social security number, Your Honor. All of that she can use to steal my identity. That is why I wanted everything done through the Family Wizard, because I do not feel comfortable with somebody having multiple felonies on them, having my personal information like that.
Okay.
I will set up anything that they're willing to outside of me or her exchanging our personal information with each other. I just don't feel like that's ideal at this moment.
Okay. Well, if you want to get to a point where you're having non-supervised possession of the child, each person is going to need to have the
Your
other.
Honor, this is another thing that I'm not understanding.
Do not
and I'm
interrupt the court, Ms. Barker. I've mentioned it several times.
I understand that, Your Honor, but I'm not there in person, so I feel like I'm not being represented. I can't speak. I'm not allowed to say anything. I'm not allowed. It's all what Miss Lovelace and what.
All right, I've got another hearing that I need to tend to. The requested relief is granted, and the court will enter the order, Ms. Lovelace, that you submitted.
I'll be suing the state of Texas. Thank you very much.
So the TRO is granted as requested and outlined by the guardian ad litem. The court will require that the parties use app close for non-emergency communications and order that the parties exchange telephone numbers only for emergency purposes. Okay. And I think we have everything that we need from you, so I will go ahead and excuse everyone from the virtual courtroom.
Thank you, Judge.
All right, thank you.
Thank you, Your Honor.
Your Honor, before we get started, may I make a motion to take it off of YouTube, given the sensitive nature of the hearing?
Let me hear from Mr. Gilbreth on that.
I don't have an opinion one way or the other.
I'm going to decline that invitation. I believe that we need to be broadcasting in order to be in compliance with the open courts provision because we are not present in the courtroom. So this is the only way we can comply. And so you may proceed.
Would you like me to proceed, Your Honor?
It's your motion, I believe. Is that right?
Yes, Your Honor.
Okay.
And so I wanted to ask first if there were any questions. I know the court will sometimes look at I think the court is supposed to look at it on its face. And so I wondered if the court had follow-up questions, or should I just reiterate what was in the application?
Well, so I guess I've seen what's in the application, and then Mr. Gilbert's office also sent, kind of their side.
Yes, Your Honor.
I think, as well as the mediated settlement agreement.
So would you, maybe I can just reiterate if I could just have just a few minutes?
That's fine.
So as the court is aware, there is an agreed injunction in place from 6 years ago, from 2018, when Ms. Stout was in treatment. And since then, the parties, as I said, have moved on with life. They've had another child. It has been an abusive marriage, abusive relationship. There have been numerous incidents, as I set out in the application, of abuse towards mom, abuse towards kids. That finally prompted her to leave approximately 2 weeks ago. She moved out of the marital residence, was able to break the lease based on the domestic violence exception in the Texas Property Code, and moved into another residence. When Mr. Stout found out that she had left him and was serious about leaving him, he pulled out this 6-year-old injunction and has, said that he intended to refuse to allow her to see the children. I immediately had Ms. Stout go and take, just quick as you can, alcohol and drug tests. Those are attached to the application for protective order, and of course, we're negative on all counts. I didn't have a way to approach the court short of a real fast hearing that I had him ordered to appear at today. Of course, I would have been seeking affirmative relief to have the children back with her on a TRO. So what we did instead was to try and mediate this case. Ultimately, we were not able to agree as to temporary orders. What we did do was agree to a Band-Aid order between when we had mediation on Wednesday of last week to today for some supervised possession for Ms. Stout. It was the only circumstance under which Mr. Stout would agree that she could see her children. And of course, we agreed without any option before today to turn that around. And so in the meantime, what has happened is that 2 or I think 3 days ago, the middle child, right? That's the one you have pictures of from previous when he's in diapers and his little training pants. That same child texted mom and said, "Dad hit me." And so Miss Stout, so as I understand it, Mr. Stout is staying with his parents in Marble Falls. And so Miss Stout called the police. The police responded. As I understand it, Mr. Stout chalked it up to a misunderstanding. The next day, the child went to school with a survival kit, essentially. He had a little like self-defense kit that had like a knife and like a little axe in it in his backpack. And when they took it from him and pulled him into the office to talk about why that was in his backpack, he broke down and was really afraid that they were going to call dad, and made the outcries that are in the school's affidavit about dad hitting mom, dad hitting brother and sister, dad hitting him. They reported to CPS. And so CPS interviewed the children yesterday, and I think sometime yesterday, and then late afternoon, the caseworker was at Ms. Stout's residence speaking with her. I spoke with her briefly on speakerphone and asked to reconnect today. And since then, I've not been able to reach her. So what we know as of now, again, is that he's made, at least this one child has made those outcries. I'm told that he made more specific outcries to the caseworker. And so with the possibility of not being reached today, we're very far down on the unassigned docket. As I said in my application, it seems untenable at this point. What I also understand is that because we have approached the court for help in this regard, that Mr. Stout is unwilling to offer her possession until the 10th. So we're in a spot where we really need some help.
All right, Mr. Gilbert.
That last part is particularly frustrating because I've been here all morning trying to work out a possession schedule to the 10th. And I will say right now we can work out possession to the 10th. A big problem is mom will not agree to testing. The evidence when a court hears this is that she's been to rehab over 10 times. She continues to consume alcohol. I think she'll tell you that she continues to consume alcohol. The prescription drugs that she's prescribed, which we have in evidence, if we have an evidentiary hearing, are one of the longest lists I guess I've ever seen in my career. And they're all prescription drugs, by the way, that we should not be consuming alcohol with, right? If I've been to rehab 9 to 10 times, I shouldn't be consuming alcohol, period. I particularly shouldn't, given the prescription drug regimen that she's on. So for Ms. Dudley to say, well, this is the only way my client gets possession till the 10th, that's not accurate. She can have possession till the 10th. She needs to test if she's going to have possession till the 10th. What's particularly crazy, I'm sorry, crazy is not a nice way to put it. What's particularly frustrating is these kids are actually going to be in tennis camp from June 2nd to June 7th, overnight tennis camp, right? That's already agreed to by the parties. You've seen the text messages where mom's already agreed that my client can have the children until then. right? And so really the period of possession we're talking about is from when they get back from tennis camp until the hearing. But let me address the ex parte protective order, which I do think, and I put this in my response, is an attempt to end round all of this. It is important to point out that, as Ms. Dudley said, well, CPS has been involved. There's no safety plan. There's no removal. There's not even a request from a safety plan from CPS. The police went out and interviewed the child. There's no intervention from the police. I have my client's counselor, I have the children's counselor logged on, Mr. Smith, in case the court has any concerns about the children in my client's possession. And Mr. Smith's logged on in case the court wants to hear from him. So it is an attempt to end round out. When they filed the application for protective order, by the way, they didn't ask for an ex parte protective order when they filed it on May 14th. There was no request for an ex parte protective order. There's no allegation that there was imminent danger. It wasn't until the child sent this text message, which again, he met with the kid's counselor after this text message, right? And if there's an evidentiary hearing, my client will testify that the boys were being violent with each other, and he did have to push the middle child away from the older child. And so the child goes and tells mom, well, dad hit me, right? And then he went and met with his counselor the next day, and there's no CPS involvement or anything. Just briefly, just by way of background, I won't go into my full opening statement, but just so you know how we got here. There is a live case. This is a live case from 2018. So the history on that is how that came about is my client Mr. Stout hired me in 2018. And you'll notice it's a SAPSR that's filed. It's not a divorce. He didn't want to file a divorce. He didn't want to get a divorce. His wife was coming out of rehab for, this was either the 9th or 10th time. And he needed court orders in place, but he didn't want to get a divorce. So we have a court order that she agreed to that says no access to the children. And then they continue, they're back together. They're not going through a divorce. I will say there's nannies in the house, but they are back together. I got a call from Ms. Dudley. Actually, I hadn't heard from the Stout family since 2018. I got a call from Ms. Dudley on May 2nd, which was a Thursday, saying Ms. Stout hired me. We're going to file a divorce. So I reached out to Mr. Stout. I didn't hear from him. On May 6th, Ms. Dudley said, well, I may need to set a hearing on everybody getting the house. And I texted her. I said, well, I haven't heard from him. But if you set a hearing, if it's on kids, it's going to need to be on the long docket. And that's having not spoke to Mr. Stout in 6 years. I just assumed they're going to need to be on the long docket. So they set it here instead. Then Mr. Stout came and met with me. He reported all the things that we will be talking about in court with mom continue to consume alcohol. I have witnesses. I have prescription drug records. She's not in sobriety. She's not safe to be taking care of the children. And I told Mr. Stout the same thing I told Ms. Dudley when I did contact her. So the information that my client's given me is I would go down to the court under normal circumstances and request a temporary restraining order. The problem with that is I have an order in place that says that mom has no access, right? I can't come in and say, give me an order that says mom has no access when I have an order that says no access. By the way, I'm shocked it wasn't DWAP'd, but that's just legally kind of where it comes to me when he has me. So we wrote Ms. Dudley and said, mom is still consuming alcohol. I have pictures of pills, upload to my exhibits, pills left in baggies, pills in the toilet, pills all over the house. And I said, so we're enforcing the injunction. That's what it is. Otherwise, I would go down and get a TRO. Then they filed their application for protective order. The day after they filed their application for protective order, that's when we went to mediation and mom agreed to supervise visits, right? And then this morning, right, I guess based on this text message from the child, which doesn't even rise to, legally, I hate corporal punishment and we're in agreement to not do corporal punishment, period, the end, because my client denies even using corporal punishment. But even if you believe the affidavit, it doesn't rise to the level. And you have CPS taking no action, police taking no action, and you have the children's counselor here. So I think it's an end round. It doesn't, and just logistically think where that would leave you, right? There's a court order in place that says mom can't have access to the children, and they're asking for a court order that says dad can't have access to the children. And so that's a situation in which we find ourselves. I guess I'll end with where I started, which is we need to get to the 10th. This should have been sent on the long docket to begin with. You've seen the text messages that are attached to my response. Yesterday, while signing an affidavit saying that these children are in danger, mom's texting dad saying keep them until tennis camp, right? After signing an affidavit, she's texting a mutual friend saying have Cole go pick up the kid's friend and drive them all to this. And then now this morning says these kids are in danger. So we need to get to the 10th. I do agree that these kids should see their mom. and I'll say it here, go outside of negotiations. I'll even say that once the kids get back from tennis camp, mom can see them if she tests in a manner that's not supervised. But and we'll do sober link testing, by the way. I understand from counsel, there's zero concerns about my client's alcohol consumption or drug usage. And we will still sober link test if they want us to sober link test. So we can have a possession schedule to get us to the 10th if mom would just test. But if not, then we just need to address it on the 10th. But the ex parte protective order is certainly not appropriate, particularly when we're here today for a hearing.
May I respond briefly, Your Honor?
Yes.
So first of all, we're not talking about just a text that Wright sent to mom that said dad hit me. We're talking about an affidavit from the head of school at Trinity Episcopal School saying we're concerned. He has made allegations that dad has hit mom and dad has hit brother, sister, and me. So that's number one. The other is this is a lot of noise and a lot of distraction surrounding her drug and alcohol abuse, talking about how many times she's been to treatment. We were candid about that in our application. She did struggle with alcohol and drug use prior to entering the manager clinic, which, as the court knows, is the foremost place to deal with grief and trauma and better understand those relationships. If the court has a concern about mom's safety under the circumstances, I mean, I think that the concern for the kids in dad's care is clear. You have the arrest affidavit, you have the pictures of her chin and of her busted lip, you have the pictures of the bruising on the back of the little baby's diaper or training pants. If the court is concerned, though, and is persuaded by, again, this noise about a 6-year-old treatment center, I have her psychiatrist sitting next to me who has treated her for 18 years, who sees her once a month or twice a month. Since April has been seeing her once a month. And so if the court has concerns about safety with mom, we can assuage those. But again, I don't want to get too far away from what is the basis of the emergency protective order, which is the very clear and present risk of danger.
Okay. All right. Let me hear from Mr. Smith. If you wouldn't mind unmuting yourself, sir. Let me just swear you in and tell me your relationship with the child and which one.
So I'm a therapist for Hollis a little bit longer than Wright. I don't have the exact dates in front of me, but I've seen them both for, approximately 2-ish years.
Okay.
And not counting the summer. Sorry. During the summer, usually they, when the travels and things like that, it's a bit hard to do Zoom with 8-9-year-olds. So yeah.
Sure. And so I don't know, Mr. Smith, have you read any of the filings by either of the parties relevant to today's hearings? As far as
just what I received yesterday and today. So I've read through them a little bit. So sorry. Yeah.
Okay. Without revealing anything in particular about your sessions, do you have concerns about the safety of these children in their father's care?
In father's care, just as of today, or just in the past of what? Sorry.
As of right now, based on
as of right now.
Today.
I mean, it's difficult to say. I'm sorry to make it say not a yes and no. It was hard, Wednesday when I saw the boys and, the story came up of what happened. So that does make me worry a bit, just for the fact of what, again, I don't know, I wasn't there, so I don't know the premise of how everything came to be. But that Wright said dad hit me. So, I mean, he looked fine to me. They all made it to the session. Dad brought them. So that's hard to answer. So, sorry.
Okay.
I get more concerned, I guess, with the kids' confusion about everything that's happening. So I guess my concern more lies upon that, just the confusion of, their living situation. I know they're with grandma and grandpa, but just that they're, the living situation and whether or not they get to see mom and things of those nature. I don't know all the other stuff. I just get to hear it from from the kids' perspective. So it's not necessarily directed at dad, but just, their confusion on what's happening and how that leads to their demeanor.
Okay. Let me just give the lawyers, I guess, do y'all have any questions for Mr. Smith?
Yes.
Okay. Just be brief. Go ahead.
Mr. Smith, you are a mandatory reporter, right? If you hear child abuse?
Yes, sir.
Okay. And after talking to the child, you did not make a CPS report, right?
No, sir.
Well, that was a point of order question. Is it right that you did not feel the need to contact Child Protective Services?
No, sir. Okay, I'll just leave it at that.
And I'm still saying it wrong. You did not contact Child Protective Services, correct?
Sorry, I did not contact CPS, so our Child Protective Services.
And the child did report, I think he was fighting with his brother when this incident happened. Is that right?
So that's hard because I think there's a couple, and I don't mean to say yes or no. I already ran that. That'd be easier. I think there's a couple different narratives, I guess. Because that was the one that he said, and he went through the story with me, but Dad was with him as well. So there was, I guess, a situation where he and brother were, fighting, and I don't know if they were roughhousing or whatnot. But he did tell me that Dad did hit him. So, but again,
go ahead.
Sorry, but I saw him physically. Again, I'm not a CPS or a doctor in a fashion of asking him to show me things. But his face looked fine, his arms looked fine. I think it was hard to kind of judge his spirits, and the fact that again, he was with Dad, and this happened just the night before. And I can't imagine how hard it was for him, and and everybody involved with what the story was with the police coming at night and things like that. So sorry.
Well, that was going to be my next question. The police actually came and talked to him as well, right?
Yes, sir. That, from my understanding, they did.
Okay. And CPS has talked to him. Is that your understanding?
Yes, I don't remember exactly how I found that, how I was told that, but yes, that DPS. I guess I'm not 100% on that. I know that the police did speak to him, his brother, and everyone involved at the house, and that CPS was notified.
Okay. And they left, the police essentially left, and the child remained with Dad, right?
That's my understanding, yes.
And for clarity, it was Mom who called, Mrs. Stout, that called the police. Is that right? Is that your understanding?
That's my understanding from what I've heard, yes.
And then are you set up? Can you see the boys, continuously see the boys weekly?
I see them every Wednesday. I see, usually Wright comes first at 9 o'clock, and then Hollis comes second at 10 o'clock.
Okay. So they're set up for next Wednesday, right?
Mm-hmm. As far as everything goes, yes.
Oh, and by the way, based on what the kid reported, the police did the same thing. I understand that you didn't see marks or anything on the child, but based on what the child reported to you, he reported that the police looked him all over his body as well. That's something that y'all are processing in the counseling session. Is that right?
Yes, he said something. He said that the police did speak to him, and they did look at him. He didn't say all over his body, but just clear. But yeah, they did look at him.
Obviously, I would have more if there's a contested hearing.
Sure, that's fine. Let me give Ms. Dudley a chance if you have questions.
Yes, ma'am. Mr. Smith, did I understand you to say that when you heard the story from Wright, Dad was present?
Yes, ma'am.
And have you had the opportunity this morning to read the affidavit from the head of school at Trinity Episcopal, where she detailed that Wright had come to school the next day and opened up a little bit more about what had happened?
I'm sorry, but just a question. Was that part of the email you sent me?
Yes, not 30
Sorry.
minutes ago or so. The application for protective order. Have you had a chance to review that affidavit?
I went through it, but I didn't see exactly the page that had that. I'm sorry. It was on my phone. So I'm sorry. I know I probably missed it.
No problem. Would the court allow me to? I'm sorry. Go ahead.
I believe that it happened. I believe Wright is a truthful person, and I believe that if that's what happened, that it did.
You believe that he is a truthful person, and if he said it happened?
Yes. Again,
Okay.
I wasn't there, but I know him to be a truthful young person, young man.
Okay. May I read you the short affidavit that Jennifer Morgan, the
Of
head of
course.
school, wrote? Is that okay with you, Your Honor?
Yeah, if you would just be brief. I think we only have a few minutes left here.
Yes, ma'am. So it says, I'm Jennifer Morgan. I'm the head of school. On Tuesday, May 21st, Wright's third grade teacher noticed a knife and survival kit containing a small axe-like tool in Wright's backpack when they were packing up the classroom. When visiting with school administrators, Wright got very emotional and shared that he didn't want to make a call home to Dad. He didn't want to get in trouble because he feared Dad would hit him. He shared that Dad hits Mom a lot, and he also hits Hollis. Wright also shared that Dad hits him when Wright gets in trouble or when he breaks things like a glass. When pressed a little further, Wright shared Dad hits him in the back and in the back of the head. Wright reports this has happened since they have been staying at Marble Falls. As mandatory reporters, the school called Child Protective Services. The items were removed from the child's backpack and remain at the school for safekeeping. So then, taking your testimony that it tells the truth and that you believe the veracity of those statements, does that give you some concern now about Wright and Dad's care?
I mean, I guess I would have to say yes. I mean,
That's
it
all.
does concern me that.
Go ahead.
Oh, sorry.
All right, Ms. Dudley, was there a police report in connection with this visit to the home?
I believe there was a police report. I've not been able to obtain it yet because it's still in processing. It just happened, I think, night before last.
Okay. But there weren't any charges or arrests made?
He was not arrested on that occasion, no.
Okay. Okay. Well, I do not like these facts or allegations really on either side. And it puts the court in a very difficult position because, my ultimate goal is to look out for the child or children involved in this situation. And normally in the face of an allegation like this, I would be very quick to grant the relief requested. However, the facts on the other side are very unfavorable to the applicant, and the conditions that have been put in place are in place for reasons that are also related to the safety and health and welfare of the children. So,
and to that end, Your Honor, would you like to speak with the psychiatrist that can give you a more current picture of her mental health and drug and alcohol use? Because your point is well taken, Your Honor. Absolutely. I just want you to have more current information because that absolutely was a concern 6 years ago. But if the court's concerned about it now, I want you to have some current info.
I have a lot to say about that if we're arguing.
No, well, y'all are out of time. So this is a short, non-evidentiary hearing where the court looks at the allegations and makes the best decision based on what I can do. Y'all need a hearing on the long docket, or you need to fully vet these issues on both sides. I understand your position is whatever, rehab is in the past, she's fine now, but those conditions are in place. And as far as I know, they may never be removed. I mean, I don't know. And I don't have the time to look into those issues today. The fact that CPS and the police department have already looked into this situation and have left the child with their father, those are facts that, are in front of the court. And I don't think I'm not going to grant the protective order application based on what I have heard. Any questions?
No, ma'am.
My client is asking if she can be heard, Your Honor.
I have my client with me as well. He has a lot to say as well. We're still on the docket. We're still on standby.
Yeah, y'all will. I have many other protective orders and TROs that have come in only the last hour in which I've been in court on this hearing and on another. And so y'all have expended your time. So no, I can't give any additional time. And
No, we can't.
So
They're not saying anything.
that's the ruling of the court. And y'all are free to confer to see whatever agreements can be reached. I hope you are reached on the afternoon docket later today, but there's no emergency relief that the court is going to grant.
Okay, well,
So-
Are we excused?
Yes, you're excused.
Thank you, ma'am.
Thank you.
Thank you.
Let's start with announcements. Counsel.
Your Honor, Scott Milner for the petitioner and movement, Brittany Ferguson.
Jacob Smith for respondent, Joseph Russell Kirby.
And just a reminder, counsel, these are short hearings. We've got one set at 2:00 after this. So I need you to be efficient. Mr. Milner, it's your amended application. You may proceed.
Yes, Your Honor. And Your Honor, if the court's had a chance to look at the affidavit and the documents attached, I'm going to go through those documents, but I just want to make sure if the court has read that, then I don't want to belabor certain points.
Okay, I have only had a cursory opportunity to go through what's in front of me because, quite frankly, the protective orders and the TROs are coming in faster than I can keep up.
Understood. Absolutely. I'm going to share my screen. Your Honor, so I'll just take the court very quickly through the timeline. So the parties were divorced in 2019, May of 2019. And prior to their divorce in 2016 and 2017, they sold some businesses and they paid a lot in taxes. And they eventually had refunds from those years, which I'm going to explain. And those refunds are what we're going to be talking about. So they were divorced in 2019, and they still had a business that had losses year after year after year, both pre-divorce losses and had losses after the divorce. And in their divorce decree, so what you're looking at is their divorce decree, and this is the applicable provision related to the refunds, that they were to split any refunds for years prior to divorce 50-50. If they came into possession of a refund, they were the constructive trustee for their spouse, and they were to send them the money, their end of the money, within 3 days. The other applicable provisions relate to a business that they were to own together, and they were going to dissolve this business very quickly. They were either going to sell it or dissolve it quickly, one or the other. So they were divorced in May of 2019, and by the summer of 2019, when they were supposed to be dissolving it, Mr. Kirby told my client, I want to keep running the business. I want to make this thing successful. She said, it's losing money. I don't want anything to do with it. And she assigned him the business in September of 2019. So everything in fairly short succession. He didn't pursue running that business. He dissolved it within 3 months. Right around the time that they were coming to this agreement, the CARES Act was making its way through Congress. And what the CARES Act did was it allowed you to take net operating losses from a business and carry it back 5 years. So if you paid a whole lot in taxes in one of those 5 years, you got to take it back, apply all of your losses to that year, and you could potentially get a huge refund. It was a great deal. So Mr. Kirby, on his 2019 taxes, had a lot of losses because of this business that the parties owned together. So I'm going to, if I can operate my computer correctly. So the parties entered into an agreement. I'm about to, sorry, bear with me, Your Honor. I'm going to stop sharing for a second. The parties entered into an agreement to roll back taxes. And here we go. And what it said was that the parties agree that they can seek refunds. And I'll just go ahead and highlight the paragraph. This is really the substantive lines of this agreement. That they agree that they can seek pre-divorce refunds with post-divorce losses, and that they'll cooperate in doing so. That's it. It didn't say, and this amends the final decree, or and they're entitled, and the other spouse isn't entitled to half the refunds. It didn't say any of that. So they did. Well, they did in part. So what they did immediately thereafter is they both applied for refunds. And you'll see this is a 1045, so it's going back and it's correcting, or it's amending their prior returns. And you'll see for Mr. Kirby, for 2016, he asked for a refund of $66,016 for 2016, and a refund of $431,183 for 2017. They were both using the same CPA to file these requests for these refunds. This is based on them rolling back these net operating loss based on the new law. The CPA also had Ms. Ferguson ask for, in 2016, $44,964 and 170,160. This was based on the CPA thinking that Mr. Kirby got post-divorce losses and Miss Ferguson only received pre-divorce losses. So she gets less, 215,000 to her and 490,000 to Mr. Kirby. We think this is wrong, but that's a little bit beside the point right now. So when the money came in, the IRS shipped it all to Mr. Kirby. So when you look at the tax return or the tax transcripts, you see that he didn't get just the 400-something thousand that he asked for, the 431,000 that he asked for. He got both his and Ms. Ferguson's return in 2022. And then he got both him and Ms. Ferguson's requested return in 2022 for 2016. So 99,000 for 2016 and 641,000 for 2017. He got it all. And he didn't tell Ms. Ferguson about it. She didn't learn about it until fairly recently. And then we filed this lawsuit. So he was, under their decree, again, her constructive trustee, and he was to pay her 1/2 of those refunds. Now, the CPA thought, or whatever, he thought that she was to receive 215,000. Well, he didn't even send her that. So we filed this suit, and we asked for earlier this month a TRO to freeze those funds so that the court could, so that they don't get spent. On Wednesday, we came to court expecting to ask for an injunction on those funds, but Mr. Kirby filed a brief that said those funds are gone. And as it turns out, those funds are gone. He spent what looks to be all or a vast majority of the funds already in that short period of time. And so it's a whole different deal because he does have about $300,000 left. It's not these funds, but it's sitting there in a brokerage account at Charles Schwab. And he's spending that at about almost $60,000 a month. It's going incredibly quick. So we can't simply enjoin the specific funds. We have to use a more extraordinary remedy. And the extraordinary remedy is a writ of attachment. We went in front of Judge De La Yata, and Judge De La Yata read this agreement here. And the argument by Mr. Kirby was, she didn't ask for her funds. I asked for my 1/2. She just didn't ask for her 1/2. And so tough luck. And it's too late. And we were scrambling at the time. What Judge De La Yata did not have the benefit of was this document showing that they did, and this document showing that she did. They did ask for the refunds. He just got all of them. And so we filed our petition for de novo. I owe Judge De La Yata an apology for not being prepared to show him these documents. He had all the money. So here's where we're at. What we've asked for is a writ of attachment, which is an extraordinary remedy. And I'll take the court quickly through what we have to show in the affidavit. And it's all based on an affidavit. It's a lot like a temporary restraining order, that he's justly indebted to the plaintiff. He doesn't have to be, it doesn't have to be a debt as in a judgment. This is a pre-judgment remedy. It's that he is justly indebted, and he received my client's money. He was holding it as a constructive trustee, and he spent it. That the attachment is not sought for the purpose of injuring him. That the plaintiff will probably lose, it says, their debt, unless the writ is issued. And Mr. Kirby, in his brief, said, essentially, they're asking to freeze all the money I've got left. So he's spending all the money he's got left at the rate of up to $60,000 per month at this time. So it's going to be gone by the time we get to trial. We're set for trial in September. And some specific grounds, as outlined down here. The ground that applies to this case more than any other is that the defendant has disposed of or is about to dispose of all or part of his property with the intent to defraud his creditors. There's no doubt that Ms. Ferguson is a creditor. There's no doubt that he knew he had her money and he spent it, and that he knew he was intending to spend that money when he spent it. And that very naturally defrauds her. So we've met these elements, and the remedy is that the court, we've uploaded an order for the court. The remedy is for the court to, and this is once again a pre-judgment remedy. There's parts of the statute that outline that this is not, it's not like you have to have a current judgment. Otherwise, this would be something else. The court asked the sheriff to get a hold of the assets and hold them until the court can make a decision on the case. And so that's what we're asking for today. We do recognize that it's an extraordinary remedy. It is a absolutely just remedy, and it would be unjust for this to happen because there will be no money left. We do have to post a bond, and we are asking that we post a bond. The bond is to cover any damages that might ensue if we were to hold it, and let's say there was, the market went up or something. Well, if it's being held, the market, it will still go up with the market. But whatever damages there are, the bond is intended to cover. So we've asked for a $50,000 bond. We're going to be in trial in September. And so we're asking that the court grant this writ, Your Honor.
All right, Mr. Smith.
Your Honor, before I start, I need to apologize to the court. My attire and my current situation, I was not expecting this morning, and actually I'm on my way to Longview, Texas for another matter. So I apologize to the court for my attire. As it relates to the particular set of facts that Mr. Milner just elaborated for the court, I disagree with his characterization of the facts. Your Honor, I am going to request the court's indulgence, as I have been on the road this morning and was on the road about the time that this was filed. I have not had the luxury of being able to file anything within the box in terms of evidence. So I am going to rely on Mr. Milner's exhibits. And if you look at the agreement on the rollbacks tax credit for years 2014 through 2018, subsection 5 specifically states that, quote, this agreement contains the entire understanding of the parties relating to the subject matter of this agreement and supersedes all prior written or oral and all contemporaneous oral agreements and understandings related to the subject matter of this agreement. The subject matter of this agreement, Your Honor, is taxes between these parties, both post-divorce losses and jointly filed marital years. Mr. Milner is relying on the parties filing a decree of divorce, but it's very clear by the language of this agreement that this agreement supersedes that final decree of divorce. Moreover, Mr. Milner is mischaracterizing Mr. Kirby's position as it relates to the TRO, insofar as one, the TRO was agreed to be dissolved because the relief requested in a TRO was wholly improper. As to the funds specifically that Mr. Milner is talking about, the assertion that there are, quote, no other resources to quote the brief, I believe is being extrapolated by Mr. Milner. And the reality is there are resources in the form of Mr. Kirby's checking account and this brokerage account. And so, for Mr. Milner to suggest that there is nothing left is a bit of a mistruth. Beyond that, Your Honor, the most important thing here is that this entire application, this third amended application, is wholly improper. Ms. Ferguson's second amended application has already been denied by Judge De La Yata. What Mr. Milner is seeking to do here is effectively seek an appeal and add in some additional facts where Judge De La Yata has expressly denied the relief requested. Beyond that, Mr. Milner has already filed a request for de novo review. He is seeking to slice the carrot 4 different ways and seek the same relief where the relief has already been denied. He is circumventing the procedural avenues in hopes of finding money for his client that his client merely has a claim to. There is no order, there is no MSA, there are no temporary orders, there is no judgment. She is merely a judgment creditor with a claim. And for those reasons, this third amended application must be denied because it is improper. Ms. Ferguson does not meet the elements of the writ of attachment. Mr. Kirby is not justly indebted. This is purely to harass and to harm Mr. Kirby. As I just expressed, this relief was already denied actually on Wednesday, Your Honor. And then on Thursday, the request for de novo review was filed. And for those reasons, this attachment must be denied.
Okay, Mr. Milner, you have the final word, but reminder that I have a 2 o'clock hearing.
Yes, Your Honor. Understood. Your Honor, we do have a right to de novo. We do have a right to bring up evidence that wasn't presented. And so this is the de novo hearing. My client has an absolute right to that. Yes, there are documents that Judge De La Yata did not see, and there is nothing wrong or improper with her bringing those up. If Mr. Kirby says, well, she just didn't ask for a refund, and so she's fresh out of luck, well, in the de novo hearing, we can bring the documents that show that she asked for a refund. Again, I'll take the court one because counsel mentioned this agreement. I'll take the court back to that. There is nothing in this agreement that changes the final decree of divorce. It says the parties may seek tax credits or refunds. It doesn't say this amends the final decree of divorce, and it also says up to 1/2. It doesn't say that the parties waive their 1/2 or that this supersedes the final decree of divorce. If it meant that, it should have said it. It doesn't say they get more than they were entitled to. It doesn't even say they may seek and they are entitled to. It just says they may seek tax credits, which they did. So I don't see that this, other than saying we're going to cooperate in seeking tax credits, I don't see that this changes anything. Now, I had previously understood Mr. Kirby to say that because this is called a post-divorce losses issue, that he could seek post-divorce losses. They still had a tremendous amount of pre-divorce losses. That's why the CPA had her taking $215,000, which Mr. Kirby took into his possession. I cannot see any possible argument where he received the money that she was supposed to get per their CPA and per their 2 returns, and he got far more, exactly the amount of hers more, as his refund. I cannot see any argument where he comes into possession of her money that she filed for, and yet he doesn't have to send that to her. I cannot see any argument. And so unjustly indebted is just that. He is unjustly indebted. In fact, he is her fiduciary. He holds it in constructive trust for her, or held it. The only reason we're not asking for an injunction on specific funds is because they're gone, and we're only left with this specific remedy.
All right, well, the court will grant the writ. And I have the proposed order that Mr. Milner submitted. I think it just needs to be updated to include the bond amount.
Yes, Your Honor.
And that takes care of it?
That's it.
Okay. All right. I think that's all for this afternoon. So seeing nothing else, y'all are excused from the virtual courtroom.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Good afternoon.
Good afternoon.
I'm assuming you put the others on notice, but I know you said they were non-responsive.
I have called the defendant that's not in prison, Mr. Albright. I emailed him the pleadings, and I believe that I included him as a courtesy copy when I filed it initially as well, to make sure that he got it.
Okay. We are on YouTube since this is remote. The 10th District Court of Travis County is now in session. The Honorable Jessica Mangrum presiding.
Henderson versus Stark, Albright et al. Mr. Darby, you may state your appearance for the record.
Jeff Darby for plaintiff Alexis Henderson.
Okay. And I heard you explain to Ms. Sear that the defendant had been copied, at least on the filing of the lawsuit. But what about the notice that this hearing was going to be set at 2 o'clock this afternoon?
I called him a couple of hours ago and left him a detailed message, as well as following that up with an email.
Okay, great. And you did not get a response, I take it?
I have not, and that's not unusual. As I put in my request for our ex parte hearing, he's received demand letters from 2 different attorneys and never responded to anything.
Okay. And Mr. Albright is the defendant who is not incarcerated at the moment?
That's correct, Your Honor.
Okay, and it's your belief that Mr. Stark is incarcerated?
According to the detective, the Travis County Sheriff's Office detective that has been assisting my client, Ms. Henderson, as of yesterday, that was the case.
Okay, great. Okay. All right, then. Well, it's your application for the TRO, so you may go ahead and go over the details again with the court. I did read this, but I've probably read another 10, 15, 20 TROs and protective orders since then. I know this is the one about the vehicle and the shop, but just refresh my recollection.
So the plaintiff, Ms. Henderson, was in an accident in mid-December. She took her vehicle into LT Collision, which is best I can tell is a sole proprietorship, and best I can tell is owned and or operated by Mr. Stark and Mr. Albright. At that time, she only dealt with Mr. Stark, the defendant that's incarcerated, and dropped off the car with simply the instructions that insurance company would be in touch. She was not asked to sign anything. I believe it was at 6:30 at night, so it was after hours. So it was a quick drop off. After a few weeks passed, she could not get in touch with Mr. Stark, the one that she had dealt with initially. And finally, she and her then boyfriend went to LT Collision to find it, I'm going to say shuttered. I don't know if it actually had shuttered windows, but it was no longer open for business. The phones are disconnected. That's something I verified yesterday before I filed the petition. When you call the number, you get this line is no longer in service message. So at that point, she reported her car stolen to the Travis County Sheriff's Office, and dealing with the detective with Travis County Sheriff's Office, she was provided Miss Defendant Albright's number, and she finally got in touch with him. Did not have very good interactions with Mr. Albright. He was very terse, threatened that if she didn't do what was being asked of her, that they would just, quote, keep the vehicle. And this went on for about a month. That's when the plaintiff hired a different counsel, which he's more a transactional attorney. That's why he's no longer involved. She didn't fire him. He just agreed to send the initial demand letter. Nothing came of it. So then she hired me. At one point, the car, she thought she was going to be able to have it considered stolen and deal with insurance only. But then, that although defendants, their rights of possession are actually pretty strong in Texas. And we don't dispute that. And we don't dispute that there is still an outstanding amount owed if indeed defendants finished the work, which we have not been able to ascertain because they won't show her the car except under their specific conditions. And considering their actions with the first insurance check of forging her signature, she has very little trust for them. So this is drug on. In mid-March, I believe, or mid-May, excuse me, with fast forwarding to where we are today, she received from her lender the notice of lien filed by defendants. It took them, I guess, that 3 weeks to get it to her because they assumed she had it because she's addressed on the demand letter, which is attached to the tax assessor collector's notice of lien. But that address is an old address. And as we've established in our pleadings, they knew her new address because they had sent an invoice to that address. And of course, my client testifies in her affidavit, she never provided the old address. She's not sure how they got it. So that, I guess, takes us to the heart of the matter, and that's whether we have a valid cause of action. For our purposes today, that is a declaratory judgment request regarding the validity of the notice of lien. And for the reasons that I set forth in our petition, is invalid. The notice of lien is invalid for several reasons. One, she didn't receive a certified mailing, which is, one, it's not indicated on their demand letter. Two, she didn't receive it at her then current address at which they had. Two, the notice of lien is actually late. If you look at Exhibit I to Miss Henderson's affidavit, the notice of lien, the defendants include an invoice of the final work, which would start the clock ticking for the 30 days to file their lien. It's dated March 25th, but it says at the bottom, work completed date is March 27th, which just doesn't really add up, especially when you consider there are two instances of forgery. The second one being the next document, the Lake Travis collision repair authorization, which is reportedly signed by plaintiff Ms. Henderson. That is clearly not her signature. And as she testifies in her affidavit, she never went back to Lake Travis collision. She went 3 times, dropped off her car. She went to see that it was closed, but those were the only 2 times she ever went. She's never seen this document. She never signed this document. And so that goes to another requirement for a valid notice of lien, that being the work order, signed work order. So that's Ms. Henderson's valid cause of action. If you go to the elements of what's required for a TRO, imminent harm, next week, the defendants would be able to transfer title to her vehicle. That's the harm. Irreparable injury. At that point, she might not have an adequate remedy at law, and she would be out of vehicle, and her lender would still be seeking payment. And so for those reasons, Ms. Henderson believes she's entitled to a TRO that we can present to the Travis County Tax Assessor Collector, directing them not to transfer title to Ms. Henderson's vehicle.
All right, and Mr. Darby, the court will grant the TRO request. I'm looking at the proposed order that you have sent in.
All of a sudden, I'm having trouble hearing you, Your
Oh,
Honor.
okay. How about this? Better?
Yeah, I don't know what happened. Earlier, I could hear you clearly, and now I can hear you, but it's very faint.
Okay. Well, the court will grant the temporary restraining order.
Thank you, Your Honor.
And I have reviewed the proposed order that you submitted. And in doing so, I do not see a paragraph or a provision that invalidates the lien that these defendants have filed. So, and I understood that to be a part of your request. So
Yes,
so it may need to be, well, it's possible that I'm just missing it, or perhaps that it was omitted in error, but I just am not finding that provision.
No, it should be added. I appreciate that. I can make that change and resubmit it. Do I submit that to the submission email?
You can just send it to Ms. Seeger. She provided the Zoom link for the hearing. So
Yes.
if you revise that and get it to us, the court will get that entered.
And just to make sure, the court is waiving any requirement for a bond.
Well, usually we include a typical one, but are you requesting that it be waived altogether?
I have, considering the defendant's conduct and really the minimal, what defendants are really seeking is $125 a day for storage.
Right. Okay.
Which is more in the vein of kidnapping the car.
Right. I'll grant
so-
the request to waive the bond as well.
Thank you.
I was just going to mention that everything has been sent through the submission folder, so that's fine if you send the order to our submission folder.
I'll copy you as well, Ms. Seeger.
I wasn't sure if my email was on that.
Yes.
Say 4-5.
Thanks.
Okay.
And
Seeing nothing else. Did somebody just drop off? No?
I think my client was logged in and she just.
Oh, yeah. There she is.
And my client is attempting to get in as well, Your Honor.
Okay. I've let a couple people back in, so let's give it a second. So I think we're here on Mr. Frazier. Is it your client's?
That's correct, Judge. And in fact, you mentioned two cause numbers. There's a pending application for protective order. So we also filed what was entitled a first amended application in a separate cause number. They're both before the court here. We're both effectively are requesting, relief for the benefit and protection of the children before the court. So just to clarify that, yes, we are the movant in both the issue before the court here today. My client is the respondent in the pending divorce matter, the cause number you referenced, but then also an applicant in a protective order.
Okay. Yes, I have I probably should have called all of the cases, but yes, they're all connected on my system here. They're
Yes,
all.
Your Honor. And so the guardian ad litem is present, Ms. Stephanie Lovelace. That just real quickly, I think the court understands that my client found out that there had been an incident of family violence inflicted allegedly by Ms. Keene, the opposing party in this matter, the mother of the two children. We've got Mila, who's 10, and Madison, who I believe is 7. And so Ms. Lovelace had a communication with Mila about the incident of family violence. We do have a recording of that if the court wants to play. It's about 11 minutes. And Ms. Lovelace also heard from the child about other incidents of family violence that are concerning and are the grounds for this extraordinary relief that we're seeking, that being a temporary ex parte protective order or a temporary protective order and a temporary restraining order. And so depending on what the court wants to do, the court can hear from Ms. Lovelace or hear testimony from the parties or recordings, videos, just whatever this court needs to make an important decision timely.
Okay.
May I respond, Your Honor?
Yes, you may. Go ahead, Ms. Ferguson.
Thank you. On behalf of Ms. Keene, I think what we just heard is that Dad recorded the child's conversation with the guardian, which is outrageous to me and extremely concerning, and a pattern of behavior that my client has pointed out to the court in her rebuttal declaration. These were siblings fighting, with Mila kicking her sister, and my client walked up and swatted her in the arm while she told her to stop. This is outrageous. There is no incident of family violence. The only history of violence was when Mr. Keene repeatedly abused my client throughout their entire marriage. Yes, she smacked her in the arm to move her away from her sister while she was actively kicking her sister. It's not an assault. It's not child abuse. I cannot believe we're here. My client absolutely did not. There was no mark. The kid saw her therapist the Thursday after. This happened last Monday. She saw her therapist on Thursday. She's in school all week. There's no CPS. There's no law enforcement. There's no emergency. This is continued abuse of my client.
Okay. All right. I would like to go ahead and hear from the guardian. I think that would be probably the most helpful for the court. Oh, you're on mute, Ms. Lovelace.
Sorry, I did that earlier today. I did have a conversation with Mila 2 days ago on Teams. And so Mila had talked to me about the incident that happened. She told me that there was an incident with her sister and that she did kick her sister, although she told me it was accidentally. She said her mother did slap her on the arm and her arm was red for at least 10 to 15 minutes. She told me that she wanted to call her dad and tell her dad what happened and that her mother would not allow her to have her phone. She told me that she referenced being hit in the face, like maybe a year ago. There's a video showing that, and she seems to be affected still by what happened. There was a mark left on her lip. And so for her with this incident, she does believe that her mother slapped her and hurt her.
Okay, associated with this recent incident of kicking from the sister.
Yeah, she stated that she accidentally kicked her sister, and she stated that her mother slapped her and stated that she had left a mark on her. It was red for about 10 to 15 minutes. And that she wanted to tell her father that she had been hit and that her mother would not give her the phone.
Okay. And Ms. Lovelace, I take it you've seen the application?
I have.
Okay. And do you, I guess, do you have any concerns with the safety and well-being of the children at this point in time, based on the application or anything else?
Well, I took into account what Mila had said to me, to the fact that, she wants to go to her mother's house, but she's afraid that she's going to get hit. So that certainly is a concern for me.
Okay. And how long have you been the guardian on this case?
I've been the guardian. Took a while to get the order signed. I believe that I've been the guardian. I think don't quote me, I believe for 4 months. I would have to look at the order again.
Okay.
I have seen the children and gone to both homes and visited with the parents.
Did you review the prior application for protective order that I believe Ms. Keene made, if I'm not mistaken?
Yes, Judge, I believe that I saw that in passing. Yes, ma'am.
Okay. Did you investigate the allegations that were made against Mr. Keene and that affidavit and that filing?
Yes, I did. And there was a denial that any family violence had occurred.
Okay.
But
I'm sorry, what was that?
oh, I'm sorry. I'm just concerned. Ms. Lovelace, are you suggesting to the court that there has been no domestic violence between these parties?
No, I'm not denying that. I'm stating that I reviewed what she asked me about, and I do know I read the protective order application, and there were allegations there was a history of family violence, and I do believe there's been family violence between the both of them.
Okay, I'm sorry, Your Honor. I just want to make sure that was clear because that's a huge point of clarification.
Yes. Okay. All right. And Ms. Lovelace, I guess my question for you is, if mom was separating children who were engaged in fighting and ended up swatting or slapping one of are you telling me that is something that you believe rises to the level that the court should take some action here today?
I do find it concerning because Neil has stated things to me similar that's happened in the past. And so I do have some concerns about her even being hit or slapped. For her, it has caused distress, and I have concerns about her emotional well-being.
Okay. You have concerns about her kicking or being violent with her sister?
No, and I do believe, Judge, that's an issue too, and that's why the child is in therapy weekly, because there are a lot of things that she has to work through. So definitely there are issues going on with Mila, and it would not surprise me that she was mean to her sister. I think she's just experiencing a lot, and that's why she's in therapy weekly.
All right. Okay.
Your Honor, may I respond, please?
Yes, that's fine.
Miss Lovelace sent an email after speaking with Mila. She didn't even ask the parties judge to refrain from corporal punishment. She instead instructed them to strike this child on the butt with a hand. So it is like, I feel like I'm in a bizarro world right now hearing this testimony from Miss Lovelace. Like, she took no action. She didn't suggest that like there should even be a restraint from corporal punishment. Instead, she said, hit her on the butt. And yet she's here telling you that she's concerned that mom like redirected her in the middle of assaulting her sibling. We're happy to agree to a unilateral bar on corporal punishment, but this is outrageous to me to remove this woman's children from her or suggest that that's appropriate in light of what we're talking about. We're talking about, I heard 2 incidents in the span of over a year.
Yeah, Judge, I mean, it gets to how many strikings of the child are we, cooperating, dealing with. We've got a relatively new guardian ad litem involved here. There's an affidavit that's been corroborated by Ms. Lovelace. She does not believe, and she can testify, she doesn't believe there's been coaching going on here, that there is the slap that we heard about that left a mark, but then also within I think the last year, hit to the child, to the face of the child, still processing and dealing with. And so, Judge, my client's got to take remedial action and protective action. He has called law enforcement. He's called CPS. I don't know what the status of either of those investigations are right now, but we do believe that family violence arises to the amount of emergency relief and protection. And I'm fine with Ms. Lovelace making even, more recommendations. She's expressed that she is definitely concerned about the safety and welfare of this child. And there's a history of violence that we're putting there. We're asking for a hearing. We're asking for a quick hearing, but protections be put in place until we can have a full-blown hearing for a court to figure out and to give Ms. Lovelace the information that she needs to make further recommendations as part of her investigation.
Well, okay, let me see if I have some questions for you. No, I didn't have time to go back and look through the prior allegations, but as far as the request for protective order that was filed in October, I think those arguably might have been more concerning, and they were denied at the time.
Yeah.
So, the request is denied. You can get this set for an evidentiary hearing. I think an agreement by the parties on the record not to use corporal punishment probably makes sense in light of the allegations, but I don't. This application can't be granted based on what I've seen. Okay, any questions?
No, Your Honor.
No, Your Honor.
All right. Okay, well, I appreciate your patience. We've got some other folks coming in behind you, so I'll excuse you from the virtual courtroom. Have a good weekend. Thank
Thanks,
you.
Your Honor.
Thank you.
So, Mr. Turner, the court has received your request, and so you may proceed.
Sure, Your Honor. We have a 10-year marriage. There's been mental health issues on behalf of Mr. Humphreys. Is set forth in the affidavit in our application on May 15th of 2024. There's an altercation that happened at the household in which Mr. Humphreys, we believe, committed family violence, placed his hands upon Ms. Humphreys. There is a dispute, as shown by the application. There was bruising, there was restraint, there was pinning Miss Humphreys down into a chair. Miss Humphreys was able to escape the situation, hid in a bush, ran down the street. Mr. Humphreys ultimately calmed down, said that he would leave the residence. He left. Miss Humphreys was in the house, locked the doors, and then Mr. Humphreys ran around the back and tried climbing in through I believe it was a bathroom window. And since that time, Miss Humphreys yelled and screamed. He ultimately left. A police report has been filed with Travis County, and that's pending. We are concerned for Mr. Humphreys coming back to the house. He's made comments to Miss Humphreys that he's going to come back. As we put in the affidavit, there's been threats that, I'm going to tell your family about things that we've done. I think also in the affidavit, we put out that there's been visual intimate material that's been created that we're worried about being disseminated. And for these reasons, we're asking for a temporary ex parte protective order and preventing Mr. Humphreys from coming back to the house. As I understand, he's not been back since the 15th, but he has made allegations that he's going to come back.
Understood. Okay. And in looking at what you've sent in, do you already have the hearing set on the 7th of June?
I have not said on the 7th. I will do. I was going to wait for the court to make the ruling, but I can have that done here in a few minutes. The 7th is our 14th day. It's the only day I could do it. Currently, I don't actually know where Mr. Humphreys is, so obviously we'll have to get service. We've got phone numbers, but we'll do what we can.
He contacted me yesterday night that he's in San Antonio at a friend's residence that I know of. I just don't know the apartment number.
Okay.
Okay. Well, based on what I've seen, the court will grant the application. And yes, Mr. Turner, if you would take care of getting that hearing set with the court administrator's office, I think that will take care of it.
Perfect. And Your Honor, real quick, we've also filed a original petition for divorce. And I believe that we submitted to the court a show cause order.
Oh.
And if I could get the court to sign off on that as well, we've made a request for temporary orders in the divorce petition. And so I want to set it all at the same time, but being two separate cause numbers, I thought I would keep that one under the divorce cause number.
Okay. And you think you're going to have enough time to take care of all of those on the 7th?
I think so, being that we have no children. We don't have a lot in the way of assets that we have to deal with. And so I think we'll have plenty of time to get in and get out with what we need.
Okay. And then in that case, so do we think there's a separate cause number then being created for that one, or?
There should be. It's my understanding that it is D1FM20.
Okay, I do have that. Okay. Yes, the court will go ahead and sign off on that as well.
Excellent.
So, yes, I didn't try that cause number. I guess I tried the one for the protective order, but
in my understanding, it seems like it changes all the time, that we're supposed to do two different cause numbers for protective orders. And so I just like the show cause and the divorce straight.
Yes. The cause numbers eventually will get linked, but right now, the protective order one is so new that it's not showing up in the system yet for me.
Okay.
Okay.
Thank you. I appreciate it. And we'll call the court admin right now and take care of that.
Okay. Thank you very much. Take care, and y'all have a good weekend.